Hello everyone. A very good morning to all present over here. I am Muskan Bendel from Electrical Department. As we gather here today, I extend a warm and heartfelt welcome to our expert, Dr. Anish Kumar Gandhi sir, our Honorable Principal, esteemed HODs of all departments, dedicated faculty members, and our cherished students. On the occasion of workshop on intellectual property rights and IP management for startup, intellectual property is crucial for startup as it can be the foundation of their competitive advantage and value proposition. This workshop is conducted under the Mentor-Mentee scheme of Ministry of Education Government of India. Government Engineering College is selected as Mentor-Mentee Institute for 5 Mentee Institutes. Currently for 5 Mentee Institutes. In this workshop, 2 sessions are there, online and offline. First session is online session. Expert for offline session is Dr. Anish Kumar Gandhi sir. He offering his service as an independent consultant to IM Legal for IPR related matter. His education qualification is BE in Production Engineering, ME in Mechanical Engineering, PhD in Mechanical Engineering, MBA in Marketing, postgraduate diploma in Intellectual Property Rights. He cleared the valuation examination for Asset Class Plant Machinery by RBPL. Please give him a big round of applause. Now I request our principal, Dr. Vidhi sir, to welcome our expert, Dr. Anish Kumar Gandhi sir. Now I request Professor Rahul Prajapati sir from Chemical Department to welcome our Honorable Principal Dr. Vidhi sir. Please give them a big round of applause. Now it's a great honor to welcome our respected principal to share a few words.
Namaskar all. A very warm good morning to today's speaker, Dr. Anish Gandhi, RM Legal Surat, Mrs. Pooja Menon, MYCrave Consultancy and Services Baroda, students and faculty members of Mentee Institutes, GIDC Navsari, Government Polytechnic Valsad, Government Polytechnic Navsari, Waghai and Gyara, and students of GEC Valsad, invited guests, participating faculty members, students joining by online mode. It's a matter of honor and pride to extend my heartfelt welcome to Dr. A.H. Gandhi and Mrs. Pooja Menon for sparing their precious time from busy schedule for today's workshop. As we have gathered here for celebrating the importance of intellectual property rights and effective IP management for startups, we recognize the invaluable role of these concepts because they play a very important role as far as innovation, creativity and economic growth is concerned. We live in a world where ideas are currency of progress. So it is imperious that we safeguard the rights of creators and innovators. We should ensure that the rights are protected and they are respected also. So as we embark on this journey of celebration, we are we have to affirm that we are committed for nurturing the environment where startups can grow and ideas can be shielded from any type of frauds whichever are possible. That's only possible if there is awareness. So this workshop we have planned today for creating an awareness. I'm sure today's experts will enlighten you regarding the trademarks, the patents, copyright, the Design Act of India. All these will definitely help you at some moment of time as you move from your college life to the industries. So once again, I thank Dr. H. Gandhi sir and Mrs. Pooja Menon, who is going to join by offline mode in the afternoon session for gracing this function. I express my thankfulness to AICT, IIC Innovation Cell for identifying GEC Valsad as a promising institute and providing all the necessary guidance, support, and funding. I also express my thankfulness to the principals, faculty members, and students of the Mentee institutes. I express my thankfulness and best wishes to the coordinators and members of IIC cell over at this institute. Thank you. Thank you all.
Now, let's give a warm round of applause as we welcome our expert, Dr. Anish Kumar Gandhi sir, to the stage to address a few words.
Good morning, all of you. Okay. So first of all, let me thank the GEC Valsad, Government of Gujarat, for giving this opportunity. And of course, today, whatever we are going to discuss, it will not be in the form of a lecture. I will try to keep it in that way. So I want your involvement also, so that we can understand. Here, we are to discuss certain important aspect. Of course, it is very introductory. I had a discussion with some of your faculties, and based on that, I am now going to deliver the content. Okay, so we are going to cover the content. Of course, it's very basic, but I will try to touch on certain very important aspects which are advanced also. Okay, after completion of this, or maybe during our discussion. So we will be defining tangible, intangible assets very briefly. Then intellectual property and its importance. Then what are the tools available in India as far as the protection of intellectual property rights are concerned. Some of the case studies are there which we'll take up in between also and at the end also. Okay, so when we look at intellectual property rights, it is very much necessary to understand what is the meaning of tangible and intangible assets. So tangible, very briefly, if I say, it is something which is existing, which can be touched, which can be feel, which is physically existing, we can say. And intangible means which is not physically existing, but it is of a great value. And why we should talk about intangible? Because when we look at the intellectual property rights, that is intangible assets. Even in the accounting also, there is an accounting for, and even in valuation also, there is a valuation for tangible and intangible assets both. Okay. So let us have a brief about this particular slide. So tangible asset means it has a physical existence, as we can see here. Intangible don't have physical existence. Tangible assets in the form of an accounting terms depreciated. So depreciation you might be knowing about. Reduction in the value of an asset over the period of time because of wear and tear. And here it is amortized. So intangible assets also gets amortized over the period of time. Much easier to liquidate as far as the tangible assets are concerned. And in case of intangible, it is not so easy to liquidate. Then cost can be easily determined. So it is all I am talking about comparative terms. In case of tangible, cost can be determined quite easily. In case of intangible, it is quite difficult to determine the cost. Okay, now what can be the example? So we all own some vehicle as an example. We all own some mobile phone. This is all what we call it as a tangible asset. There are many examples. Our house property, there are some plants and equipments. Okay, these are all coming under tangible assets. So what is intangible? So intangible assets we are going to discuss today. Okay, like patent, design, trademark or a brand name, logo, okay, geographical indications. So these are all coming under the category of intangible assets. Even data, when you look at, so data will come under the category of tangible or intangible. See, data has a great value nowadays. Okay, if we look at the softwares, these are also coming under the category of intangible assets. Okay, now before moving ahead, if I talk about the tangible assets, so what proves your ownership as far as the tangible assets are concerned? When you are saying that this vehicle is of mine or it is a my vehicle, so what proves your ownership? How you can say that? It is RC book. We know this as an RC book. So there is some registration in your name and you are issued, okay, some proof for that in the form of an RC book. Suppose if it is a house property, we call it as a certificate, say registration certificate, or we call it as a, say, dastavej as an example. So when it is in your name, okay, you can say that it is my property. Okay, now when say it is your property, what you can do with that? When I am saying that this particular property I am having an ownership of that, so what ownership rights you are enjoying? Suppose if I take an example of a house property or any vehicle, suppose four-wheeler, I can use it for my own purpose. So that is the first right. Second, I can sell it off. Okay, that is the second ownership right. Third, I can rent it to someone else and can have some income in the form of a rent. That is the third ownership right. I can transfer it. I can transfer it. Okay, say like father is transferring the property to son or a daughter maybe, or maybe some other relative, or maybe some other person. Okay, now, so these are all what we call it as an ownership rights. Along with it, there are many others. If we talk about intangible assets also, similar to the tangible assets, okay, you can have some ownership rights. Almost these are the same rights. Okay, we will discuss when we'll go through the detail of that. So what proves the ownership in that case also? That also we will discuss. So this is something about what we call it as a tangible, intangible assets. Okay, patent and whatever we other rights we are going to discuss, these are falling under category of a intangible assets. So what is intellectual property? So to understand intellectual property, we should focus on individual words and meaning. Intellectual and second is a property. So intellectual property refers to the creation of mind, as you can see here. Okay, now in today's context, I want to redefine this definition, what it can be. Only I am talking about creation of a mind. We need to now clearly write here creation of human mind. Why we need to add that? Because of now introduction of the artificial intelligence, AI. So through the AI we are creating artificial minds, you can say. Artificial machines are there which can think of, which can reiterate, which can create something which is of value. But intellectual property rights are applicable to only the creation of human mind, and lot of policy changes and thought processes going on all over the world, how to take care of the creation of AI. Okay, so still nobody has given the say official you can say permission to grant the patent or maybe some certificate to the creations, which is the creation of a AI. I am having some cases also, that also we will discuss if time permits. So intellectual property refers to creation of human mind, such as invention, literary and artistic work, design, symbol, name, images used in commerce. Intellectual property is divided into two categories. So these two categories are, as you can see here, industrial property and copyright related property. So now when you look at industrial property, it includes patents for invention, trademarks, industrial designs, and geographical indications. Okay, how many of you know the GI? Have you heard the word, what we call it as a geographical indication or a GI? કેટલા સ્ટુડન્ટ્સ છે જેને GI જેવું કંઈક સાંભળ્યું છે? At least I hope you might have heard that word. Okay, we are going to discuss that what do you mean by GI as a part of introduction. So when you look at copyright, copyright covers literary work such as novel, poem, any story which you have written, so that is all covered under copyright. Film and music, artistic work such as paintings, photograph, drawing, sculpture, okay. And rights related to copyright includes those of performing artist also, who is performing some act, so that is also covered under that. I will take it up later on part. So why intellectual property matters? That is an important question. Okay, why tangible property matters? That is another question which I am asking to you. We have talked about some ownership right. Now suppose if somebody start using your house property without your permission, then what you can do? Legal action somebody is talking about. See, I am having an option. If I don't want to do anything, fine, I'll allowing them to use it. I am not taking any action, right? But if I want that they should stop using, then as an owner it is my responsibility to take an action. So you are available with a registration certificate or some registration document. It does not mean that government will take care of your property. Are you getting what I am saying? It is our property, so we have to take care of it. If somebody is using it in unauthorized way, we have to initiate an action to stop that. But as you are available with the registration document, your legal system in a country will help you to impose your right. Are you getting what I mean to say? Suppose somebody has started using my property and I am trying to stop them, but they are not considering me, and by force they are using it, and you do not have a capacity to stop them at your level. In that case, you have or you are available with the support of a judiciary system. Okay, you can use it and you can enforce your right. So this is the case where your registration will be important. Now, why intellectual property matters? So creativity and inventiveness are vital. They spur the economic growth. Okay, now when we are talking about these economic growth and other things, just I wanted to discuss here one thing. Are you aware of any statistics related to the patent filing in a various countries? So suppose if I talk about US, China and India. US, China and India. So if we look at the US, whatever the figure I am giving is approximate figures. In US filings, patent filings per year, somewhere around 6.5 lakhs. 6.5 lakhs per annum. In China, this is somewhere around 40 lakhs per annum. 40 lakhs per annum. In India, we know that a lot of growth is there over the period of time. Growth is highest all over the world. but you can say that figure is approximately 60,000 around a year. 60,000 in India, US 6.5 lakhs approximate, China 40 lakhs approximate. If you look at any developed countries, okay, intellectual property applications are of course on a very higher side. And as an India, we are targeting on developed country by 2047. Okay, and you cannot be a developed country without giving importance to your intellectual property creations. So, intellectual property creates economic growth. It is very important for any country, for any company, an individual. It creates the job. Okay, so now I am giving you another example. The progress and well-being of humanity depends on our capacity to come up with new ideas and creations. My clients, you see, I am not going to read anything out of it. I'll just take that and make you to understand. We all have passed through the pandemic situations. Okay? And up to the larger extent, what has helped us to come out of that? Vaccination. Okay, so development of vaccine, and then vaccinations programs were taken up. So that you can say it was a very important point that vaccine should be developed and should be made available to the people. So when you look at even say development of vaccine, the companies are investing a lot. Okay. Now once the vaccine is developed, and then after say they are not given any rights to protect it, and government say that it should be available to everyone and anyone can manufacture it and sell it off, what will happen in future? The company who has developed the vaccine, who has invested in development of that, in a future, if such a pandemic may come, then those companies will not invest in it. Are you getting what I mean to say? So it is a huge loss to the society. Of course, we cannot allow that company in such a situation, okay, to exploit the situation by offering the vaccine at a very high price. But of course, at the same time, we should also give them some profit, some reward for what they have developed. Okay, so there should be a win-win situation on which we need to work upon. So well-being of humanity I am talking about here, and intellectual property rights will help in that case. Technological progress requires development and application of new invention. See, when I was at your age, maybe first year, so we were available in 1992. When we want to purchase some two-wheeler, hardly 2-3 options. Bajaj scooter, then Vespa was there, and maybe some bike from the Honda CD100. Nowadays, if you think of purchasing a two-wheeler, lot many options. You will get confused. What to purchase, what to not. Every day almost one new product is coming into the market. So why it has happened now? It is because of fast technological development. Okay, so IPR is also important as far as this fast technological development and the growth is concerned. How? I am not going into much detail of that. Okay, so most important part here is providing an incentive for author or an inventor to develop and share the information rather than keeping it secret. So IPR is very important as far as this point is concerned. Now I am discussing with you one case here. You might be aware that at a school level, every year, many say drawing competitions are coming. Okay, child is maybe at the age of, you can consider senior KG, junior KG, like that. Very fresh minds, small children. Companies are coming up with some drawing competition. Suppose the topic is draw your dream car. Draw your dream car. तो सबको एक sketch बनाना है. Okay, and there are big companies coming up with such a contest, maybe on a various states level, national level, across the geographical areas in the world. Okay, what may be the reason? ऐसा क्यों करती है कंपनी? उनको ड्राइंग कंपटीशन करवाना है खाली. तो there is a deep thinking behind. Companies want fresh ideas, and we are all biased at this age as far as our thinking pattern is concerned. We have lot many boundaries which we have built up. But as far as the small children are concerned, they are with a great creativity, fresh minds, and they come up with a very good outputs in the form of a sketches and drawing. They want to utilize it. Second thing is, suppose there are two children who are sitting side by side. One is drawing something. Okay, when other student try to look at, normally what we try to do? The particular children, we try to hide it. कि मैं आपको क्यों दिखाऊं? I'll hide it. Okay, now what is that mentality? Why it should be? Okay, there is a fear that particular person will copy my drawing. Okay, copy तो कर लिया. Then what is the advantage to me? I am now coming to second situation. The person who is sitting side by, the child who is sitting side by is quite थोड़ा सा वो एडवांस है. तो वो बंदे को बोलेगा कि आई एम गिविंग यू वन टॉफी, आई एम अवेलेबल विद, अलाउ मी टू सी. पॉसिबल, इट मे बी नेगोशिएटेड. ઓકે, તું મને ટ્રોફી આપે છે ને, જોઈ લે મારું ડ્રોઈંગ. What I mean to talk about here is, whenever we develop something, we are in the fear that once I will disclose it to the public, public will start copying it, they start using it, making it. What is my advantage in that case? So better I don't want to disclose. So what is happening now? A very good things might have been created. If it is really practiced and offered to the public, it may be of a great help and of great requirement. But the particular person or a company is not disclosing because of that fear. Okay, so there is a loss everywhere. Individual person who has developed is at loss, not getting anything. Develop किया, but it has not been communicated, not had been commercialized. Society को loss हुआ, that would be a good solution, good product, but not available because it has not been shared. Okay, so what IPR right says that when you create something new, will provide you the protection to you, but against that there is your responsibility. What is your responsibility? Your responsibility is to share your invention with the society. એટલે મેં કંઈ ક્રિએટ કર્યું છે, મારે બીજાને બધાને ડિસ્ક્લોઝ કરવાનું, બધાને નોલેજ થાય, but they cannot practice it without my permission because I have been given a rights to that. Okay, why it is so? Once the things will be disclosed to the public, public will come to know about that technology, and if they are doing some further development, they will start developing from that point, and it will avoid the repetition of what has been done. Okay, so providing an incentive for an author or the innovator to develop, share information. Now I know that when I develop something, my rights will be protected, and those rights I can utilize for my own benefits, and that's why I'll be happy to share it and to protect it. Okay. So let us understand this. There are total in India, if we talk about 8 different property rights which are available to protect your intellectual creations. So one is a patent, another is a design, then there is a trademark, copyright, then there is a Semiconductor Integrated Circuit Layout Design Act, geographical indication, Plant Variety and Protection Act, and trade secrets. So there are total 8 different rights which are available in India. Any of your intellectual creation will at least be protected out of any of this. So if you are developing something which is an intangible asset, definitely you can have a protection in any one of this. Okay, which is qualifying for what? We will understand when we'll go through the detail. So normally what companies are doing? Companies are using bundle of right, means more than one right, to protect their intellectual creations very strongly. Suppose I have given one example here. Which different intellectual property rights can be obtained as far as one product which has been shown in the diagram. So this is what we call it is a CNC vertical machine. Now to correlate in more generality, okay, I am saying that you consider your mobile phone, which is one product. Okay, so how many different intellectual property rights can be used to protect that particular intellectual creations? So one is a patent. So if we look at that machine is available with some mechanism, some technology on which it works in order to give the output. If we look at your mobile phones, okay, of course, there are some mechanisms, some systems which has been provided, and it is a combination of maybe software, hardware, okay, on which it works. So all those systems can be protected under patent. Then if we look at the design, so how your mobile phone looks like, how that machine looks like. So for that you can have a design patent. So we are talking about patent, also known as a utility patent in some other countries. Then we are talking about design patent. In India it is also known as a design patent or industrial design or design registration. Okay, so overall outer look can be protected, only look and not the functionality, not the working principle. The brand name what you are using, say the machine is from Siemens, so they are writing Siemens, model number of that. Your mobile is say from Samsung or maybe from Apple, so they are writing that logo, company name. So this is all protected under trademark. As far as the machine working is concerned, say some software is required. As far as your mobile phone is considered, some software is required to work on. Say Android system we are talking about. Okay, or maybe some other system we are talking about. So that is protected under copyright. Inside the mobile phone, inside the machine control unit, you will have some integrated circuit layouts, some control cards. So that can be protected under Semiconductor Integrated Circuit Layout Design. Okay, control card jene kehavaય ne. So I will have some small video here, then we will discuss that what different intellectual property rights can be utilized here. So please look at this small video. You might have referred this earlier somewhere, but this I like the most as far as the understanding of invention is concerned, innovation is concerned, and understanding of the various tools which we can apply here.
Slide માંથી બહાર જશે. Try to let us. લાઈવ માં નથી દેખાતું ને સર, એટલે પ્રોબ્લેમ લાઈવ માં નથી દેખાતું. હું ટ્રાય કરી લઉં. લાઈવ માં નથી જતું. પછી એક જ મિનિટ, એક જ મિનિટ કઈ સાઉન્ડ
So if we go through this video, it will help us to understand a very important aspect, that to which type of invention we can apply which type of tool. Not only that, it will help us to understand what is the meaning of invention and the innovation, okay, for which we can have an intellectual property right protection. આપણા વાળાને તો દેખાય આપણા વાળાને તો
આપણે તો દેખાય.
બસ ચાલશે ઓકે
Other nation in the world, almost 900 kilometers per person. But that also means we have 350,000 bike-related injuries. Now imagine that we would make biking safer, smarter and easier by applying self-driving technology to biking. We taught our self-driving bike to figure out where it is,
Just observe this
what's
video
around
and
it,
I'll make
what
you
will happen
understand
next,
later on.
and what it should do. We leaned on Google's expertise in self-driving cars, but we had to adapt the technology to work on a bike. We decided to add 2 additional features. First, you can request the bike to pick you up wherever you are, and we developed a comfort mode, adjusting the pedals to a perfect resting position.
I think the self-riding bike could really give a boost to the economy because people could also work on their bicycle. You work in your office, you work in your home, you work in your car. You could even work on your bike.
I have so much more time. My kids love it. They're just free. They can go anywhere they want, anytime they want. It's amazing.
At the Fietsersbond, we feel that this is the biggest invention since the invention of the bicycle itself.
At Google, we always put our users first. With the launch of this bike, we believe we do that again.
So just to narrate you, sorry sound was not there, but I can make you to understand. See, this was the product which was introduced in the year 2016 around by the Google. And nowadays even many more other options are also available. This is what we call it as a self-driving bicycle. Okay, can we consider this as an innovation? So we need to understand what is the definition of innovation. So it is creating something new. See, creating something new. We are talking about new word here, which is very important. Creating something new. New means which is not existing earlier. Which is not existing earlier means before introduction of this, it was not available. So creating something new, now that is not enough. Creating something new which is of value. Which is of value. So if we are creating something new which is of value, either it may be a product or it may be a process, then we can have a patent protection on that. Okay, so now if we look at this, this is a self-driving bicycle. So the first feature is it is a self-driving. It will drive at its own as per your feed requirement. So it can be connected to the mobile phone. You can call it from the parking to your location. You can set the Google map there. It can take you to the place. You need not require to drive. It takes care of the other traffic condition also. It can be set to the leisure mode, which is more comfortable. You can work while driving on that, you might have seen. That lady was the mayor of that particular city, and she had taken this test drive where you might have seen that she had been shown working on the laptop. Okay, you can set the program, and without your invention, your small child can take some visit of some places. There is a self-balancing technology you might have seen here. देखा आपने, it was a self-balancing technology. So this is one of the technology for which you can have a patent. Self-driving feature for which you can have a patent. How it looks like, how it is appealing to the human eye in the form of a bicycle. For that you can have a design registration. For that you can have a design registration. Google itself, if you look at the logo, the word, so there is a trademark registration. It works on some software. You need to write some program to make it operate. So that can be protected under copyright. Okay, so always the companies are using bundle of rights. Now there is another case. Can you see the left figure? So left figure talks about some PET bottles of some of the cold drinks. Okay, so which are the different intellectual property rights which can be applied here? So suppose if I talk about the shape of the bottle itself, how it looks like, shape of the tin, how it looks like, how it appeals to the human. For that there is a design. Whatever the logo is printed there, say Coca-Cola is there, Fanta is there, any other taglines are there, these are all protected under trademark. If you look at the formulation inside, okay, for that it can have a patent, but Coca-Cola has used the trade secret to protect it. So I will also come to that particular point. Bottling plants, whatever the mechanism is used there in the bottling plants, maybe some transport solutions, you have designed some specific carriage to carry this bottle in a bulk from one place to next place. All other related things can be protected under the patent. If you look at the right side, so there is one packaging of a tea. So outer packaging can be protected under design. Okay. वाघ बकरी जो लिखा हुआ है can be protected under trademark. और कुछ लिखा हुआ है Darjeeling, pure Darjeeling tea. Can anybody write Darjeeling tea? Suppose the tea has been grown in Assam. Can you sell it under this particular packaging? No. Why it is no? The reason is there is a GI tag available for Darjeeling tea. So you are in a Valsad, so very well known for Alfonso. So there was one case law before 3 years, 3 to 5 years. Ratnagiri people had applied for GI tag for Alfonso, Afus. Afus jene ke Alfonso mango. And they had proved that actually originally the Alfonso was grown there. From there it has been taken to this area. So its origin is Ratnagiri and not the Valsad. So it cannot be sold under the Alfonso name. They were assigned the GI. Now Valsadi Alfonso is coming up with. Now where there is an effect. So there was a huge export market for Alfonso mango, Afus કેરી. ડોલરમાં વેચાય એક નંગ. એ તો જે લોકો ધંધો કરતા એમને ખબર હશે કે ગુડ ક્વોલિટીની જે બનાવીને પછી એક નંગ ડોલરમાં જતા હોય. Now once it is exported, if it is not grown in the Ratnagiri and if you are exporting under the name of Alfonso, it will not be allowed. So automatically the competition to the people who are dealing in this business from Ratnagiri will cut off, because no Valsadi mangoes can be exported under the name of Alfonso, because they are handling a GI tag for them. So we are talking about now one more here, that is what we call it as a GI. Okay, if we look at the next, there is some pump which is used by some of the patient of asthma, so that can be protected under design. Even its design, critical design, you can put the capsule inside, you can rotate it, it will break, medicine will be released and it can be inhaled, so that can be protected under the patent. Even this packaging, rotahaler, whatever has been written, that packaging can be protected under design, and some specific features are given inside to take care of that medicine. It can be protected under patent also. Formulation of that medicine itself has some formulation that is protected under the patent. So what is patent? Now that questions we are putting up here. Patent is a monopoly right granted for what? For an invention. Invention may be product or a process. Who is granting that right? By the government. To whom? To the inventor who has invented it, or to his assigner, to whom they are assigning the right. Now how the inventor and assignees are different. So suppose tomorrow you are getting the job in one company. Okay, suppose you are the computer engineer or maybe the mechanical engineer. Say mechanical engineer are getting the job in some company. Suppose company name is Vari Limited and they are developing some specific solution, okay, which utilizes the solar energy. You are the part of that development team, so you are the inventor. But when the patent will be applied for, okay, applicant will be the company, because company is paying you for whatever the products you are developing. So there will be an agreement of yours with the company that whatever the intellectual property creations will be there, ownership will lies with the company and not with you. So you can be inventor and your assignee will be the company. Okay, so applicant enjoys the ownership right, whereas inventor enjoys moral right. Okay, now what is your advantage in that case? Once the patent is filed, it is granted, your name will be there as an inventor forever. You can use it on your biodata. Not only that, other companies who are looking for a good researcher in that area, they may contact you based on the details which are available. Okay, so these are the advantages to the inventors. And of course, inventor can also work for some financial benefits and sharing. Then patent is granted for limited period of time. It is not like that once the patent is granted, forever you are enjoying the rights. So the life is 20 years from the date of filing. So once that 20 years is over, the technology is open to all. Then it is valid within the country of grant. So that's why it is known as, it is a territorial right. Okay, many times the people are asking the question that, can we have an international patent? So there is nothing like an international patent. If I want to enjoy the patent right in India, I have to apply to the Indian Patent Office, I have to pass through the procedure, and if it is granted, I can enforce my right only in India. If I want to have a patent in USA, I need to file a patent application to USPTO, US Patent and Trademark Office. Similar process as per their act and law, it has to pass through. And if it is granted, you can impose your right in US. Similarly, if I want to enjoy my right in China, in European Union countries, there are total 39 European Union countries which are coming under European Union. I need to separately apply for patent in each and every country. I have to pass through the procedure, and if I am getting the grant, I can enforce my right. So it's really costly process. Not only that, needs a lot of skill. Each and every country is having a different act and law, and we have to act per their act and law. Suppose one patent is granted in USA, it does not mean it will be granted in India. And if some patent is granted in India, it does not guarantee that it will be granted in other country. Everywhere it will be examined separately, and it will be interpreted based on their act and law. And we came across a very well-known case study from the past where one cancer drug was developed by one of the multinational, and they were holding the patent in 40 countries, but it was denied in India. And it was challenged by that company, okay, to all the levels. All the levels means with the patent office at that time IPAB was available, Intellectual Property Appellate Board. तो पहले तो वहाँ पे challenge किया. Okay, again they lost. Then they approached to the Supreme Court of India. Again they lost. Then they approached the WIPO also, World Intellectual Property Organization, and some of the options available in United Nations. But they could not get the patent. So what I mean to say is it is a territorial right. Okay, so if I am holding a patent in India only, other person who is sitting in China or maybe in US, they can copy your things and they can sell it off there. Only the limitation is, in other country you are making it and entering into India, it will not be allowed because India is your territory. And by manufacturing in India and to export it to the other countries for doing this in an unauthorized way, it will also not be allowed. Are you getting what I mean to say? Okay. Now another question here is, I am a pharmaceutical company, or suppose I am a company like a mobile phone manufacturer, okay, where there is a huge requirement all over the world. So how I can protect it? It is quite difficult. There are 205 to 7 countries. And even if you pick the major countries, it may comes out to be more than 65. So can we file a patent application at a time in all the countries? It is not possible. So to help in that case, there are some treaties which has been designed. One is what we call it as a Paris Convention, and another which is what we call it as a Patent Cooperation Treaty, PCT. I am not going into much detail, but you can utilize these two treaties and it will help you to channelize or to distribute your say investment over the period of time, and to get or to give you some time for your strategic decisions of entering into the other countries. So there is nothing like international patent. Okay. What is innovation? Already we have discussed. Innovation is a process and outcome of creating something new which is of value, or a new way of doing something. Even if you are coming up with some methodology of doing something in a different way, that is also protected under the patent. Traditionally, the focus should be on new product and a process. Okay, design engineering subject पढ़ते हो आप लोग? So here there is a core. वहाँ पे तो कोई ध्यान नहीं देता है, मुझे मालूम. Taking it subsidiary. But it is very important. Once you go to the practice, actually that thing you are doing, and that is of requirement. So when you look at the innovation, the whole process is from opportunity identification, ideation or invention, then to the development, then development of prototype model, and production, marketing and sales. See, you pick up any product, any process which is successful nowadays in a practice, all has passed through these stages. Are you agree with? Are you agree with this or not? Vaccine development, one example. Opportunity identification. There was an opportunity. There was a requirement in the market. And if you come up with that solution, Okay, it is of requirement and you can earn money out of it. So opportunity was there. That's why many companies has jumped into ideation or invention to development. So there is an opportunity to need to develop some vaccine. Now you are designing your vaccine, how you will go about, which process needs to be followed. So you are going development on that. You are coming up with some samples, which we call it as a prototyping. Then you are testing it to the, as per the FDA norms, as far as vaccine is concerned. Or maybe if it is an automobile in an on-road conditions, and whether it is satisfying all the government criterias or not. So that is a prototyping. And then once you are ready with your final product, there is a stage called commercialization. So whatever you are learning in the design engineering is really of great importance, and all people are doing it. Actually your whole commercial market exists on that. Today it is said that involve the capacity to quickly adopt by adopting new innovation, that is a product, process, strategies, organization, etc. From the patent point of view, what should be your target? You should focus on development of new product or a process. Okay, so now there are some examples of the patent which has changed the world. See, there are two types of invention. I define it into two categories. One, what we call it as a breakthrough invention, and another what we call it as an incremental innovation or incremental inventions. Okay, breakthrough inventions I have given here some of them. Breakthrough means a very disruptive, which has changed the way in which we are working, completely disrupt the certain existing technology. Okay, as an example, driverless car, though it has not got any official say acceptance all over the world, but a lot of work is going on here. Already people have applied for the patent also, and some of them have patent on this also. In India also, in Bhopal, there is one of the startup companies doing excellent work. They are all from the IIT, doing work on this particular aspect. Okay, so driverless car, if it is coming, it is going to change the way in which we are working. Magnetic levitation already in existence, and we could achieve a very high speed because of this particular concept. Motorized exoskeleton, not only to support the physically weak people, also to do some physical work in an industry where a lot of stress is coming to the various body parts of the workers. There also it has been used. Drone technology. Okay, many different examples are there. We are using it in e-commerce, we are using it for surveillance, we are using it for say certain defense requirement. N number of examples are there. 3D printing technology. It has changed the world in which we are working. Now even buildings are printed. Bionic eye. This is one artificial eye which has been created and can give a vision to the person, okay, who is not having a vision from its birth itself. So there is a technology. Even people have come up with global positioning system. It has changed the world. Earlier when we were going outside, we were going with a map, and we used to stop the people and asking for the address. Now that has gone. Gene editing. It's not new technology. I had one case study. It was developed first time in the 1972. Genentech was the company. Genetic engineering technology. So they were the two professors, very excellent story. I am not taking up here, but that is one case study which I always discuss when we talk about the startups and why the patents are important and how it can give you the economic benefits over the period of time. So based on this, even insulin is developed based on this. Graphene structures, invisible structure, can take up the load of a whole building like this, but it is not visible with naked eye. Can you imagine such a structure? It is available. People have developed in some of the IITs I came across that they have developed the single layer structure of carbon atoms, and which is capable of taking the huge load. Bluetooth technology, solar panels. It has changed the world. Okay. Wireless mobile communication. પહેલા તો ટેલિફોન માંડ માંડ મળતા, પછી પેલા પેજર આવ્યા, and within 2 years mobile has come and it has disrupted everything. Okay. Virtual reality, meta world and all that you might be aware of, augmented reality, virtual reality. So with this I hope that I have communicated what is patent and what for what type of things you can have a patent. So this is all what we call it as a say today is a 5G technology, which is also what we call it as a breakthrough innovation. Incremental means, see, first patent was given in say drone, but it does not mean then for drone related things you will not have any further patents. You keep on doing some small improvements in order to overcome the previous problems or in order to apply the same technology to the newer fields looking to the requirement, then of course you can also have a patent. Suppose the patent was granted to one of the computing system. Over the period of time continuous there is an improvement, faster and faster machine, smaller and smaller size, and you can have a patent on that. So that is what we call it as an incremental innovation. Okay, trademark, very quickly now I will take it up. Design I will make you to understand within 5 minutes. I will take some time on that, which is very important. So trademark is a sign which is capable of distinguishing. Trademark क्यों यूज होता है, क्या पता पड़ता है उसमें? ट्रेडमार्क क्यों इंपॉर्टेंट है? See, it is distinguishing goods or services of one enterprise from those of others. Okay, so why it is important? Suppose I am talking about a very common example, as even symbol is here. I am talking about milk bag which is available from Amul. Now we are visiting some store. There are 2 milk bags of same price. One is with Amul, another is no branding is there. No branding, कुछ भी नहीं है उसके ऊपर. What you will prefer? Amul. So what that symbol is doing, it is distinguishing one product from the other. Okay, now let us take up some other example. I am talking about shoes. Okay, so in a shoes, Skechers is there, Adidas is there, Nike is there. Okay, Action shoes is also there. So if you look at those symbols, those names, this is differentiating the product and services offered by the different manufacturers or service providers. These are some of the examples I am giving you. Jio, Airtel, BSNL, VI related to service. Okay, communication. Samsung, Apple, electronic appliances, mobile phones, laptops. Pepsi, Coca-Cola. Again another category. Some soft drink products. Covaxin, Covishield. We talked about vaccines. Okay, now I am not going into the much detail here. Now this is important. What you can protect under trademark. So various signs. I think most of the things you will be in a position to identify. Okay, McDonald's and Facebook and all. Words like Coca-Cola, eBay, IBM, Google. Letters, HP, LG, LG, KTM. Numbers, 94.3 FM. Okay, then like this. Drawings. Drawings ma પહેલું કયું છે? Very famous. Just looking at symbol you could identify. Why? because that symbols gives the differentiation of a product which is offered by this company, and there is an importance. अब कल आप अपनी कुछ कैफे खोल रहे हो, उसमें ये सिंबल यूज करने लगो, तो आपको क्या लगता है? You will get an advantage, no? मिलेगा कि नहीं मिलेगा एडवांटेज? मिलेगा, डेफिनेटली मिलेगा. But then are you allowed to use it? Clear? Because to develop the brand is not an easy. People are consistently putting lot of efforts, money, time in order to come up with a branding. Branding means consistent product of some minimum level of quality, and that creates a branding. Okay? Then miscellaneous landmarks are there. Celebrity trademark can also be there, provided you need to take up the permission from that celebrity also. Emblems can be protected like this. Even shape of goods. Acha, KitKat no shape kevo hai? KitKat. So that is protected under shape of goods. Okay, these are some biscuits also, KitKat also. Okay, sound marks. Can you give some example of a sound mark? See, many times when we hear one tune, we identify that this is the product from this particular company. Ulala ulala olelo. Okay. Once you say this, you identify what we are talking about. Titan. Titan ની પણ એક ટ્યુન છે બહુ ફેમસ. અહીંયા બહુ ચેન્જ ઓવર કરવા પડે છે એટલે I am not playing it, but it is available. Okay, so once you heard the tune, okay, another you can say the non-conventional marks are smell, sound and taste. Can you protect the sound, say smell as a trademark? It is very different thing, but it is there. And there are some examples. Say example I have included here. How about the smell of freshly cut grass from a tennis ball? Would be a winner? So we are talking about one tennis ball. उसमें से smell कौन सी आ रही है? Grass की smell आ रही है. Okay, there are some very famous smell, very identifiable, like bubble gum smell. So even if you are coming up with something very specific, okay, and if you protect it, that will also become your own brand. Once I enter into this room, if that smell is there, I can identify that this is the brand. Okay, so that's why these are very rare, but it is very important, and of course you can protect it. Protection is somewhat difficult and different than the conventional trademarks. So example of smell, bubblegum scent for sandals, and strawberry, cherry, grape lubricants for combustion engines. Okay, so these are protected. There are some service marks. ISI લગેલું હોય. Okay, આ જે green and red, veg, non-veg. So these are also, you cannot use it, but you have to take some permission, some certification, and then you can use it on your products. So there is a difference between trademark, service mark, collective mark. I am not going into detail. Doctor નું જે symbol છે ને, CA નું જે symbol છે, that is what we call it as a collective mark. There should be symbol for engineers. We are asking for, but not available, I think. So that is what we call it as a collective mark we can have. Okay, GI ના થોડાક example જોઈશું. Geographical indication. Now that word itself is very important. Geography. So something which is associated with a geographical region. Okay, that can be protected. Okay, now whatever Ratnagiri, Alfonso we are getting, that quality, that taste, everywhere it cannot be grown. It can be grown only in that area because of the quality of a land, characteristics of say, or say maybe environmental parameters, and that helps. Kesar cannot be grown everywhere. But we know that it can be grown only in some Kashmir and some other cold regions. And because of that atmosphere, it is having that own characteristics and product. Okay, this is about something which is we are creating out of the natural product, farming. But suppose there is some area, geographical region where there is some skill of doing something. As an example, Solapuri chappal, manufactured only in Solapur, and only the people who are in that region is having the skill to come up with that product. So that can be protected. Okay, what is the advantage we'll discuss here. So Kesar mango, Talala Kesar, it is protected under GI. Okay. So these are some of the examples. Okay, Tirupati Laddu, protected under GI. Kanchivaram Sari, Kolhapuri Chappal, Darjeeling tea, Assam tea, Nagpur orange. Okay, Kashmir Pashmina shawl, that is protected under GI. There are many examples. Bikaneri Bhujia. સુરતમાં જીઆઈ લઈ શકાય છે પણ લેતા નથી. ઘારીનું લઈ શકાય એમ છે, લોચોનું બી કદાચ આવી શકે છે. That taste, skill not available. You will not get the same taste everywhere. Okay, now the question is, who will get GI? So GI will not be given to an individual person or a company or a firm, but it will be given to an association. And whomsoever is a member of that association can use that particular tag on their own product. So as an example, in suppose we talk about some area like Darjeeling. So in a Darjeeling there is an association of tea merchants. એમાં બધા જ આવી જાય. ધારો કે કોઈ ફાર્મિંગ કરતું હોય, કોઈ પેકિંગ કરતું હોય, કોઈ પ્રોસેસિંગ કરતું હોય, કોઈ માર્કેટિંગ સેલિંગ કરતું હોય. So they are all the members of that association. Once you become a member of that association, and if that association is having the GI tag on Darjeeling tea, you can use it on your own product while selling it. So that ensures that Darjeeling, whatever the Darjeeling tea is being written, it is originated and grown in that particular area only and not from anywhere else. And that ensures its quality. Okay, so that's why it is very important. I'll just take 2-3 minutes and we'll stop it. Copyright we know, so I am not going into much detail. Okay, patent life 20 years, GI 10 years but renewable after every 10 years. Trademark initially given for 10 years but you can renew it for unlimited period of time. Copyright, life of originator plus 60 years. Life of originator plus 60 years means at the age of 20 you have created something, or one person has created something. He is living up to 90 years. So 90 minus 20 and 70 years तो हो गए. After that originator or creator expires, 60 years more. So that is the life of the copyright. Okay, there are many examples which are given here. I would not like to go into the much detail. Semiconductor integrated layout circuit, though this Act and law is available in India, not many people have up till now say utilize it in order to have a protection. Okay, plant variety and protection. For that you cannot have a patent. Okay, all of you know that whomsoever is in farming, you are purchasing some seeds from market. તમારે ખેતી કરવી હોય, કોઈ પાક લેવો હોય તો તમે શું કરો? સીડ માર્કેટમાંથી ખરીદતા હો. And even quality depends on what type of seeds you are purchasing. So there is one example available from one of the company that is named as a suicide. Okay, there is a what we call it as a GERD technology. So there is a suicide seeds of a cotton. So for one time you are purchasing, okay, you can use it to grow the crop. Now once you grow the crop, again you are available with a seed. But if you use that seed now again for farming, it cannot be grown to the crop. So these are genetically modified seeds known as a suicide seeds. Why company is doing that? So every time you need to purchase a new seeds, and that will create a market. But though people are purchasing because it is giving you the good quality of a cotton. Okay, so that type of things can be protected not only in the patent. There's a section 3 in the Patent Act which talks about non-patentable subject matter. Whatever is there in a non-patentable subject matter, these are protected under any of the other act. We need to look at that which can be applied. Trade secrets. Simple example in a trade secret is you are winner until the time up to which you are maintaining your secrets. Once your formula is disclosed, you are loser. People will start copying it. Okay, so you have to maintain the secret, and you are a winner up to the time you maintain your secrets. And that policy has been successfully adopted by Coca-Cola, a very well-known trade secret example, KFC chickens. Then we are talking about Microsoft. They are also following the trade secrets. एक डिजाइन નું થોડુંક તમને એક્ઝામ્પલ આપી દઉં, then we'll stop here. So design means you can protect only aesthetic aspects, not the way of working, not the technicality. Okay, now why it is important? Suppose you have taken a decision to purchase two-wheeler. Many times it is happening that out of your choice of 5, which is within your budget, meeting your specification, then you take a final choice maybe based on how it appeals your eyes, how it looks like. Nano has been failed. The major reason was it looks. People could not accept it look. Okay, there are many examples of the product where because of its aesthetic aspects it is sold, and with aesthetic aspects even the brands are associated. Apple no phone bo normal dekhai chhe, barabar, but if somebody is coming up with a phone which looks like same and start selling, it can have a market, because there are many other people, they don't want to spend huge money on Apple phone, but they want a phone looks like Apple. હું લઈને ફરતો હું તો કોઈને લોગોને કશું નથી દેખાતું, ખાલી ફોન દેખાય, તો people may perceive that he is using Apple phone, so that gives him a say importance. So brand is also associated with a design which has been given. Another example is there is a huge or say different categories of the product which has been stored at same place. Railway station पर normally આપણી પાસે 2-5 મિનિટ હોય, ટ્રેનમાંથી ઉતરીએ, કંઈ ખરીદી કરીએ, સપોઝ આઈ એમ ઇન્ટરેસ્ટેડ ઇન જ્યુસ, એટલા બધા મૂકેલા હોય. હવે એમાં ડિફરન્શિએટ કરવા માટે હું કોઈક સ્પેસ સેપ આપું, જેમ કે પેપર બોટ જ્યુસીસ, કંઈક અલગ છે, મને ખબર છે કે આ તો મને સારું લાગે છે, ક્વોલિટી સારી છે, immediately I will take a choice out of it. Okay, so that is what we call it as a design. So design can be applied to any machines, equipments, technical products, day-to-day items, consumables. So there are many examples. Design in everyday life I've given you. This is related to home appliances. Okay, design can be protected. Furniture items, consumable products or consumer products, pharmaceutical. Even જે આપણી ટેબ્લેટ જે દેખાતી હોય ને અલગ અલગ કલરમાં હોય, અલગ અલગ એનો લુક હોય, that is also protected under designs. Textile jewelry, textiles and jewelry. Even diamond polishing, polished diamond કેવો દેખાય એના facets, this is also protected under design. Machines, how it looks like. Automobiles, even automobile ની each and every individual item પણ થઈ શકે. જેમ કે સ્પોક વ્હીલ્સ છે તો એના વ્હીલની પેટર્ન, સ્ટીયરિંગ છે તો સ્ટીયરિંગ, સીટ્સ છે તો સીટ્સ, એનું બોનેટ નો શેપ છે તો એ હેડલાઇટ્સ કેન બી પ્રોટેક્ટેડ સેપરેટલી ઓલ્સો. Okay, so with this actually I wanted to stop here. I just try to communicate today what we call it as, okay, this is just a last slide. How much intellectual property is there in a cup of tea? This is very important and very good example which has been published by WIPO. So can we discuss this? If we look at the tea, suppose we talk about kettle, cups, saucer, sets. Okay, so for that you can have a design. Suppose I have come up with some tea making equipment which is a unique in design and can give you a good tea. So that technology can be protected under patent. Method of sorting the tea out of the farm, processing the tea, raw tea out of the farm, packaging it, various packaging machines, all this can be protected under the patent. It can be protected under GI also if it is from particular origin. Okay, so we are talking about just one tea, but almost trademark and other things also is applied, like Tata tea, Samara tea, Jivraj 9. So these are all the brand names, what we call it as. So that can be protected under the, or we say using bundle of rights. And always it is important to utilize bundle of rights if you want to have a maximum protection on your intellectual property right. Okay, so there is a very good example of Tata Nano where the company has utilized maximum number of intellectual property right to protect it. And you can have some case study if you get the time out of the Google itself. So with this just I wanted to conclude here. Thank you.
Thank you very much, Lisa, for providing us an insight into the IPR. પોલિટેકનિકના સ્ટુડન્ટ્સ અને એન્જિનિયરિંગના સ્ટુડન્ટ્સ બંને ટેકનિકલ સાઇડથી છે. પાછળથી કદાચ મને નાના નાના એવા પ્રશ્નો ધ્યાનમાં હતા કે વિદ્યાર્થીઓને અસાઇનમેન્ટ સાથે કરાવવાનું છે, સબમિશન કરાવવાનું છે. આપણે અહીંથી મુંબઈ જવું હોય, બેંગ્લોર જવું હોય, કોલકાતા જવું હોય તો આપણે જ્યાં સુધી ટ્રેન કે બસ અથવા તો હવાઈ જહાજ નહીં પકડીએ ત્યાં સુધી ફક્ત રિક્ષાઓ પકડી અને મુંબઈ, કોલકાતા કે બેંગ્લોર નહીં જઈ શકાય. એટલે આપણા વિઝન અને ટાર્ગેટ અલ્ટિમેટલી ભણવાનો ગોલ, તમારા સ્ટડીનો ગોલ કેવો છે, બહુ મોટો હોવો જોઈએ. ફક્ત આપણે અસાઇનમેન્ટ સબમિશન પૂરતા જ રહી જશું અને ટેકનિકલના બધા જ વર્ષો પૂરા કરી મૂકશું તો 8 વર્ષો ત્યારે આપણી પાસે એવું કોઈ વિઝન નહીં હોય તો હવે આપણે શું કરવાનું છે. તમે બહાર જઈને કોઈ એવું પૂછશે નહીં કે તમારું સબમિશન કેટલા ટાઈમની થયું હતું કે તમે બરાબર અસાઇનમેન્ટ લખી નથી હતા. Yeah, there are also necessary and they are the parts. તમને અહીંથી ટ્રેનમાં જવું હોય તો ઘરેથી પહેલા તમે રિક્ષા પકડશો, ઘરે ટ્રેન નહીં આવે કે હવાઈ જહાજ નહીં આવે. So you need to go to bus stand, you need to go to railway station but ultimately you have to focus on your particular journey. That is the main journey. Okay, so ઘણા બધાને ઘણી બધી સાંભળીને હોય છે કે નાની નાની મેટરમાં તમને બેસવામાં પણ કદાચ ક્યારેક એવું થતું હોય કે ક્યારના બેસાડી રાખે છે જ્યાં સુધી there is no pain no gain. કે ઘણી વખત સારી વસ્તુ મેળવવા માટે આપણે એટલીસ્ટ આટલું તો સેક્રિફાઈસ કરી શકીએ આપણો સમય. ઓકે, wow. Okay. So finally, I would like to thank all the students present over here, because without you this program is not possible. I would like to thank Dr. V.D. Dhiman sir, our principal sir. I would also like to thank faculty members and principal heads of the Department of Polytechnics, heads of the Departments of Government Engineering College, Valsad. I would also like to thank to Rahul sir and Vijay sir for technical support, Srivastav sir and all IIC and SSIP, both of the members, those have done so many work for conducting smoothly this program. So not taking time here, I would like to invite Dr. V.D. Dhiman sir to present a memento to our guest, Dr. Anis. Please. So thank you very much for all. One more announcement. We are going to start one more session at 1:45. So you have to get that one again after taking a short break. Our canteen is running very well. So you just go to the canteen, have a breakfast and come back, please. Thank you.